when Gerald asked me to do this, we discussed the possible topics, and the possible topics are sort of contracts between publishers and authors, contracts between publishers and filmmakers and TV channels. The other possible area was intellectual property, and the third area was defamation. When your questions came in, surprise, surprise, the interest was all in relation to libel. That's what you all want to know about. Kevin's the star of the night. Kevin's a very experienced defamation lawyer. We act for Private Eye and the Mirror Group, the Express Group. We did the Penguin, what's his name, David Irving. Case for Penguin. So Kevin's a very experienced lawyer. We've got a very large department dealing with defamation issues. So you've asked the right questions of the right people. Claire's now going to introduce the question and answer session.
I'm not going to
The woman in the check jacket.
I know. Well, thanks ever so much for coming along. As Gerald said earlier, we set up the IBP Futures Group in January of this year, and I got together with a group of journalists and some colleagues from the PR industry, some of which who are here, which is great, to talk about what younger people wanted to get out of IBP and what was bothering us. And we spoke about various career issues and the issue of libel law and editors not being very impressed when you said I've got this big sexy story that's quite contentious was something that was mentioned by nearly all of the journalists in the room. And I've been speaking to Davenport Lyons tonight, and they agree with me that the amount of litigation is going down at the moment because of the times we're in. People don't want to risk the money of suing, and sadly, I speak from experience on this one, publishers and editors don't often want to back those stories that may result in us being sued. And another cost-cutting measure that I've noticed is the kind of abolition of the annual libel training day, which we all used to have a few years ago. I don't know if we could have a show of hands. Has anyone been on a libel training day in the last year or ever? Okay, a couple of hands. See, this used to be like a requirement of your firm's legal insurance that all of the journalists were routinely once a year sent off to hear some usually very entertaining cases of what not to do, and that's something that has sadly fallen by the wayside. So the whole point of tonight was to put you in front of some experts who can really give you, well, we're going to start off with Kevin. He's going to start going through the salient points of defamation, what it is, what the standard defences to defamation are, some common mistakes to avoid. I've got a few questions here that people have submitted in advance that I'll keep peppering in. But it would be really helpful if there's anything you want to ask, just put your hand up, but tell us who you are and where you come from, if you don't mind, just so we can network a bit, and we'll carry on like that. But so, Kevin, take us through the basics of defamation. What is it?
Okay. Would anyone like to have a guess as to what defamation is?
I think that's a no.
That's a no, isn't it? I mean, if you do get say you get a solicitor's letter, all that a complainant has to show to pursue a claim for libel is firstly that the article refers to him or her or it if it's a company. So that the article is about them. So that's the first thing they have to prove. The second thing they have to show is that article has been published, which, and in the people in this room, there's not normally very much doubt that something has been published because it's in a magazine or newspaper or whatever. So there's really hardly any argument about that. And the third thing they have to show is that the words, or it could be a picture, a photograph as well, are defamatory. No one wants to have a go what defamatory is? Yep. Yeah.
It is words that lower you in the estimation of like thinking person.
Very good.
Textbook.
Yeah. Yes, it's a words or pictures or any statement, or even an expression of opinion, which we'll come on to later on, which lowers the person concerned in the eyes of right-minded members of society generally. So basically, if the article makes the reader, the ordinary reader, think less of the subject of the article, then that is a defamatory article. Libel and slander. Libel is if it's in permanent form, basically if it's written down. Slander if it's spoken. But I don't think slander normally bothers most of us, and there's very few slander cases or complaints. But all your stuff. Yes. Oh, they're not on. They're not microphones. They're just recording for the. Can you not hear?
There's 4 seats at the front. If you want to move nearer the front, if you're a bit.
Philip, can you give me a wave if you can you hear? I know you don't want to, but do you? Okay.
Welcome to the front.
So they're the elements of a basic claim for defamation: reference to the complainant, publication, and that the article is defamatory. And that's all a claimant, as we call them these days, has to show. They don't have to show that the words are untrue. That's for the defendant if they can. They just have to say, here we are. This article has been published. I'm going to threaten you, but please publish an apology, or I'm going to sue for damages unless you correct it and put it right. They don't have to do any more. They don't even have to show that they've suffered any damage. Damage is presumed, as in most cases, if you fall over, break your leg, and all the rest of it, you have to claim some loss. Or if you want to sue for breach of contract, you've got to show you've suffered some damage. But in libel, damage, as I say, is presumed. That's because libel is all about reputation, and it's very difficult for anyone to actually prove that they've suffered actual loss as a result of the publication of an article. The rationale behind it is that people don't speak to you. You don't know that people are avoiding you. You don't know that people are talking about you behind your back. You don't know that they're not giving you their next job or the next contract or whatever because of what they've read in the newspaper. And that's why you don't have to prove that damage. It's, as I say, damage to your reputation is presumed.
So how do we defend ourselves when we get the shitty letter through saying don't like what you've written, we're gonna sue, or we want an apology?
Okay, there's a number of defendants of defences. The best one is called justification, which is basically truth. And truth is a defence in libel terms, is a defence to everything. You don't have to show that you have acted reasonably. You don't have to show that you haven't been malicious. You can be as malicious as you like. If you can prove that something is true, then that's a complete defence. It's the trump card. But the problem is, I'm not sure how many card players there are. There's not that many trumps in the pack. And in order to succeed in the defence of justification or truth, it's very, very difficult because the onus is on the publisher to prove the truth. Not every to every last letter, but the substantial sting of the libel you have to prove is true. The claimant doesn't have to do anything, because not only is damage presumed, but it's also the article is presumed to be false. So
is this why editors are so touchy nowadays about documents? So I did a story a few weeks ago about Bradford and Bingley suing a load of solicitors, and they wouldn't publish it until they had a letter, even though we didn't publish the letter, saying that this was going on. And as soon as they saw that, it all went through. So is that basically why?
Yeah, and lawyers would call that evidence, I suppose. But it is in order to prove the truth of something, it's proof to the standard which would be accepted in a law court. So just because, well, I heard it my mate in the pub, I'm sure it's true. everyone knows it's true. Of course it's true. It must be true. It doesn't work. You've got to
So you need
demonstrate.
to really need all your contacts and say, can you send me the email, or can
you need your
give me
your sources,
a copy of that?
yeah. Your documents. How are you? I mean, we'll come on to. I think one of the. I think there was a question later on about journalists and what they can do and how they can protect themselves. And the best thing to do is to have all the evidence so that you can stack up and prove what you've written. Because, as I say, if you can do that, that's a complete defence. So that's the best one. The next defence is referred to as fair comment, which they've changed the name slightly. Is now honest comment, which is basically an opinion. You can express an opinion, provided, because everyone, it's free speech, freedom of expression. You can express an opinion, provided it's based on true facts. It's really, as I say, an extension of free speech. That's what free speech is all about. But it's got to be an honest opinion. You can't express something that you don't genuinely believe, or if it's based on some untrue facts. But honest comment, honest opinion is a defence to a claim for libel. Not always easy to prove, and until recently there were very few cases which had succeeded. There's been one or two in recent years. But that's not an easy one to run. First of all, to actually determine what is an opinion, an expression of opinion, and what is a statement of fact. It's not.
And is this trickier when you're dealing with like an editorial leader or a column or a blog, even where someone is expressing a strong opinion, as opposed to an article which, of course, should never contain any opinion and be completely balanced and entirely based on the facts?
No, articles can contain opinions. It depends what the purpose of the article is. Is it to state facts and tell the reader, well, this is the position, this is the truth, or is it to express an opinion? I did a case quite a few years ago about an architect. The headline was "The Destroyer of Dublin." That was fine because you knocked down all these old Georgian buildings. That was okay. We could have defended that on the basis that it's honest comment. Prince Charles would have loved us, but so that was fine. But we went on to say how he was taking backhanders from planning or paying backhanders to planning people. So, and that wasn't so good.
Was he?
No, he wasn't, and we paid up. But,
oh, what a shame.
But as I say, there's a difference there.
I know what architects are paid nowadays. I wouldn't be surprised if that was the case. So that's fair comment.
That's fair comment. The last one of any importance is privilege. A number of types of privilege. As far as we're concerned, there's the statutory privilege, which is that you can publish reports, public inquiries, what goes on in court, what goes on in Parliament, all these various reports of public. You can publish. And even if it's untrue, so long as a fair and accurate report of that public inquiry, of what someone says in court, what they say at the inquiry, what they say in public documents, provided you have not acted maliciously and it's a fair and accurate report of what's been said, then that's a defence to a claim for libel. This also overlaps with something that I should make clear. There's something which is called by lawyers the repetition rule, and it's something that a lot of journalists get wrong. And the rule is that if you publish something that someone else has said, even though you're not the author of this, you simply say, last night Mr. X said that Mr. Y was a murderer. You have published that libel in the same way as if you were Mr. X. So merely by repeating something that has been said elsewhere, means that you are just as responsible and could be sued to the same extent as the original person that made the statement. So simply by saying last night, so it was said that, you can't then say, well, there we are, it's true, it was said last night. Mr. X did say that Mr. Y was this, that, and the other. That's not a defence, because the wrong in libel is not making the statement in the first place. It's the publishing of the false state of the defamatory statement. So lots of people go wrong by looking at other newspapers and other articles, or even public reports, and saying, oh well, it's been said over there. Oh, they said that last week or last month. I can happily repeat it. You can't. You can be sued to the same extent as the original person. And that's why we need defences of privilege, of reporting what goes on in Parliament and other. Because if we didn't have these privileges, then every time if you have someone in court making allegations about someone else, or in Parliament, or in a public inquiry making allegations, and a newspaper reports those allegations, they would have to prove the truth of them in order to defend it. If we didn't have these defences of privilege, and that's the repetition rule.
And what about the Reynolds defence? Because that's what we threatened against the last baby man.
Yeah, Reynolds' defence is. I think when it came out, all publishers and journalists thought that their Christmases and birthdays had all come at once, but soon found out that they weren't getting any presents. I'm afraid the Reynolds defence has succeeded in some cases, but not many, and that's the defence of responsible journalism. This is where, if what you publish is true, as I said before, the trump card, the defence of truth, is a complete defence. You don't need to rely on Reynolds, because if you can prove it's true, that's fine, whether you're responsible or not. But if it's untrue, there is a possible escape route through Reynolds. But in order to rely on that, you have to show that the subject matter of your entire story is in the public interest and has some public concern
it's
about
like a
it.
rogue trader type defence.
Or some, yes, but there is a real public interest. The next one, which lots of journalists I think forget about, is that the defamatory statement, the bad things they've said about the person concerned, has to make a real contribution to the story. You can't have a story and say, well, this is all about the public interest, it's all about this building, and by the way, Mr. So-and-so is committing adultery, which has got nothing to do with the story. So it's got to have a real contribution to the story. And thirdly, the journalist has got to act responsibly and should have checked and gone through quite a rigorous investigation as to where, before just putting pen to paper, to have contacted the person, looked into it, investigated why do we have to publish now, and you should always think, what if this is untrue? If I publish this and it's untrue, do I still think that there is a real benefit and a real public interest? Am I being responsible in publishing this article when I know it's untrue, if it is untrue? And most journalists, when they ask themselves that question, will probably say, well, if it's no, and I haven't investigated sufficiently.
Or if they don't, their editors certainly
Their
will.
editors certainly
But could you tell us a bit more about the Reynolds case? Not in huge detail, but it's one that does keep coming up. And
it's called Reynolds because it's named after the Reynolds who was the Prime Minister of Northern Ireland. The story about him was a political story about him, what he'd been up to, and that sort of thing. And it was said, well, this is, and lots of these Reynolds cases come in with a political context, it was said, well, this story is in the public interest. The public have a right to know. We've acted responsibly, even though this story is completely untrue. we've still acted responsibly in publishing these untrue allegations about him, because it's better that the public know these untrue things than it's more important than his reputation. The court said, yes, there is such a defence, but it doesn't apply here. So
from there,
and from there we have the so-called Reynolds defence, which, as I say, has operated in a number of cases. But there's been a recent case which was a police officer who was being investigated by the police for taking bribes from Russian oligarchs. He brought, and the story was that he was under investigation, and a police officer under investigation. This police officer is called D.S. Flood. The allegations are that he took bribes from this person and that person. He did this, that, and the other, but it was still under investigation. As it turned out, he was totally innocent, or he couldn't be proved to be guilty. More accurate, perhaps. Anyway, so the allegations were untrue, but the newspaper tried to run the defence of Reynolds' defence on the basis that there was a huge public interest in police officers taking bribes, etc., etc. Tick, they were okay on that. But the court said, well, yes, that's fair enough, but you didn't have to go so far as to name this person, and even if it was right to name him, you didn't have to set out all the allegations, these uncorroborated, unsubstantiated allegations which were being made against him, in order to write your public interest article. And although the first judge, agreed that it was covered by Reynolds' privilege, it went to the Court of Appeal, who said no, the privilege doesn't apply.
So you had to pay out on that one.
I had to pay out on that one. It's probably still going. But.
Oh gosh. And I've got a question here from James Carnegie at Aylwin Comms. Do you want to kick off?
Hi, yeah. I want to know if you can libel the dead.
No.
Oh, that was quick. Any others? But is this true? Because you hear it all the time. You can't libel the dead.
It is
write
true.
anything you like about Robert Maxwell.
You can.
No one will pop up.
You can. I think the reason for it is, as I said at the outset, what defamation is all about is someone's reputation, and the concern is that if you write things that make everyone think less of someone, then they're going to be avoided, they're not going to get jobs, they're not going to be promoted, and so if you're dead, you don't really care about that. And also, it's all about embarrassment and hurt feelings, and again, if you're dead, you can't get embarrassed or have your feelings hurt. So I think that's basically what it is. But you have to be a little bit. Sometimes you have to be careful that if you talk about Robert Maxwell and you can say whatever you like about him, if you say, well, he or was part of a member of a family that criminal past and blah blah blah, then you may run full foul of actually libeling someone else. His wife, his brother, his sister, or whatever it might be, who happens to still be alive, and they say, well, by saying that allegation rubs off on me, and I'm still alive.
I have another question from Stephen.
Stephen Walworth here from Investment Chronicle. I just wanted to ask about you always see in articles so and so refused to comment or declined to comment, all that kind of thing. What are the rules guiding that when you have to say it? Would you get in trouble if you said something about the party and you hadn't got a comment?
No, I mean it depends. I mean, if your article is right, and more importantly, you can prove it's right, then you don't have to ask for comment at all.
So is it just a defence in case you're wrong? It would be easier to prove to suggest that you've been acting falsely if you had gone to the different party as well.
Yeah, I mean, on this Reynolds, if you're trying to write the sort of article which is in the public interest and you're acting responsibly, and you need to rely on Reynolds because you can't prove what you've said is true, i.e., so it's false, it's defamatory, and so it lowers the person in the eyes of the public or right-thinking members of society. and you want to try and say, well, nevertheless, I know it's untrue, but I should have published that because there's a public interest and I've acted responsibly, then yes, you ought to have contacted the person. If they refuse to comment, then fine. But there's other hoops that you should go, you should try to investigate. Just by phoning up and saying, "Do you want to comment on this?" and they say no, and you say, "Oh, great, okay, I can just refuse to comment. I'll go ahead and publish." That's not good enough. You've still got to investigate. What's the source of your story? Why do you think it's true? What's your evidence? Where's your documents? Do you need to publish today? Why can't you publish next week? Is there such an urgency in publishing the thing? Where have you got your information? Do your sources have an axe to grind? Why do you believe them? Have you challenged them? Why do you believe that this story is true? What if it's not?
Nick, you had your hand up first.
Presumably then, using unnamed sources is not going to stand up for proving the truth.
Yes, I mean the journalists, as you know, shouldn't identify their sources, and it sometimes puts journalists in a very difficult position because they've got a very reliable source. They've got this information. They want to show that they've acted responsibly. They've used this source for the last 10 years, always come up with the goods, etc., etc. But the source won't be identified, and even worse, can't hand over any documents, etc., etc. It does put the journalist in a very difficult position.
But simply from a legal position, does it not? It doesn't mean that you can't defend without revealing sources.
No, it depends. I mean, if your stories, if you think you can prove your story is true, without revealing the sources, yes, that's fine. But it is often difficult to prove something is true if you can't bring your source along. But if the source, if you give you lots of documents to prove it, you don't have to identify where you got them from.
But if you can't reveal it, then they can pay out.
Well, if you can't prove it's true, or you can't rely on one of the other defences, and it does make life much more difficult. But a case did succeed, a case called of Jamil, which was all about Saudi Arabia, and the court accepted that the journalists couldn't reveal their sources because all their sources would be killed. So
neat.
It was, and that was accepted, and the Reynolds defence succeeded on that occasion.
And I should have said that Nick's from Inside Housing. We've got a story about Inside Housing.
Oh, come on to that.
Uh-huh. Okay, sorry, the lady with the black hair and glasses.
Hi.
Who are you? Tell us who you are. I've been rudely
My
assumed.
name is Miriam. I'm with Reuters.
Oh, there you are.
One of the issues that we run into, especially because we're a financial wire, is that I'm with the television side, is that we have a series of analysts come in for various topics of the day, breaking news. In a situation when we have analysts commenting on a specific topic or a specific story, where does the responsibility lie? Is it with us who has picked, for example, movies to come and make a point about a specific financial institution that's not doing well? Is it with them if their comment is defamatory in any way or liable in any way?
You're broadcasting, so you're responsible.
And how
They might be responsible as well, and they probably are, but you're broadcasting this to the millions of sorry?
If it's live, it's sometimes difficult to control.
But you're still, I know, but you're still broadcasting the libel. You're, as I say, it goes back to this publishing. It's not the author. It's the wrong is publishing. As was said in the case along, there's a world of difference between someone in the pub overhearing a conversation between two guys at the bar, one saying, "Oh, this guy's a crook," and one person hears it, to him running out, going to the newspaper and saying, "This guy, it's been said in the pub that this guy is a crook," that is then published to millions of readers.
So it's the vehicle.
It's the vehicle which
the
is
way you deliver it.
it's the person or company responsible for delivering it, publishing it.
So how should Reuters and other? I mean, lots of us do, television, video type stuff on our websites as well. Should we be given guidelines to commentators and saying, don't say this because it could be construed as a libel? Or if it's live, in your case, is there something that the presenter should say, like you sometimes see on BBC when somebody uses the F word and they immediately go, "Oh, that's very, very naughty," and give
Well,
them a
yes, I mean,
spank
I don't have technically whether that's why you do have delays and 10-second delays, whatever it might be on stuff that you can stop it if it comes out, and you often see people trying to do things to put things right or make it not so bad, and I think if you do, if someone comes out and you say, well, okay, that's that's just an opinion or whatever, that's his opinion, and we obviously we don't know whether it's true or false, etc., and we're obviously going to contact the company to ask them for their views, and they're going to come in next week or tomorrow or whatever it might be. Then it's really a bit of damage limitation.
Okay, and so we've got another. The lady was first. We'll come to you next.
Hi, Hannah Davies from the Bookseller magazine. So, how long has a claimant got to sue? As in, how long do you need to keep things like transcripts?
Good question.
The limitation period is 1 year from the date. What the lawyers would say the cause of action arose or accrued, but that's not quite so easy.
Does the internet make this more difficult?
It does, because we have what's called a multiple publication rule, which is that because I keep going back to it's the publication which is the wrong. So and it's not when something was first written; it's the date it is published. But every time, and take the internet, every time someone can access a website and to read something on the internet, that's a fresh publication. And so your 1 year limitation period
goes on and on.
Runs from that. And this, one of the problems which I think applies to all our law really is that we're trying to apply old law to new media and new situations all the time, whether it be copyright. The Copyright Act came in 1708 or whatever. They hadn't really thought of CDs or downloads and that sort of thing in 300 years ago. And in the same way, we're applying the old law, and it's an old case of the Duke of Brunswick in 1849. Which is the case which we are applying to the internet today on publication, and that was this. A book had been published years before, some 6 years before or so, and he found out about it, a bit fed up about it, and so he got his manservant to go and actually get a book, purchase a book, hunted high and low to find where he could get hold of this book. Bought it, then said, there we are, publication. Limitation starts all over again, and sued and won. So say internet publication. It's the same with books. I mean, if you put out a review, if a book is still available to the public, then it's still being published. It's not quite so, but certainly on the internet, if it's accessible and you can read it, then there's no issues of limitation.
I find never throw anything away is a very good rule in life, generally.
Yeah.
But, I have lots of cupboards.
Yes, I mean, if you're going to keep them for a year, maybe.
You think they would have sort of kicked off after?
Yes, normally.
Okay, and the chap with the stripy jumper, sorry.
I am Clive, I'm a freelance sub-editor. I mainly work at Ink Publishing. I thought in terms of actually proving something, I'm sort of a bit mystified as to what constitutes proof. If you're quoting somebody, if you've got shorthand notes, there's nothing to say you didn't just take down a load of old rubbish, make up shorthand notes. If you've got somebody on tape, you're interviewing them over the phone, is that proof, or could could you have got in an impersonator where the courts just throw that out?
It's much better evidence than I normally get. My journalists normally record over their tapes, or lose them, or can't find their notes.
Yeah.
So you're ahead if you've got some notes and you've got a tape. Yeah.
What if it's wiretapped? I mean, if you're going on to wiretap someone, is that? I mean, I can just imagine. The court can throw out evidence of CCTV camera if it's not good quality about someone committing an offence.
I think most of the cases you do, and certainly most of the ones I've been involved in, they don't actually get to court.
No.
Court is like when you really can't agree and both sides have got huge amounts of money. I mean, most of these problems will settle. I mean, maybe we should come on to settling.
Why
we don't want to go on for too much. Because I can sense that people are thirsty.
Right. Yeah.
But yes, sorry.
From Alison. Just, I might be asking you to speak a bit outside non-UK law, but why do people say, perhaps in summary, why America is more liberal? What are the essential differences with American law as distinct from British or English law?
They have the First Amendment to the US Constitution, which guarantees for free speech. Is actually a much bigger thing. Although we obviously have the right to freedom of expression and all the rest of it. It's a much bigger thing in the States, and they also have what's called a public figure defence. So if someone is in the public, you can more or less say whatever you like about them, unless that person can prove you've been malicious. So it's just a different law. It is a much more publisher-friendly law.
Okay. Oh, good. Horace, questions. You were first on the end there.
Michael Brown from Charter Institute Building. Is there an equivalent defamation for organisations as opposed to individuals?
Yes. And the lots of companies and businesses, associations, and there's one a recent case, let's say limited companies, trading companies sue all the time because they have a business reputation to protect, just as people have a personal reputation. So, and normally those, I mean, the lady from Reuters will know that the financial information, if you say a company's doing badly, losing money, going bust, and all the rest of it, they have the right to sue. And recently, the British Chiropractic or whatever it is, Society brought an action against a Mr. Singh. So that was an association.
Is it still liable?
It's still liable.
Mm-hmm.
Yeah.
The chap with the glasses in the middle row. Yes, you.
Jonathan Williams from a financial magazine called IP. We had a story recently where a Swiss company, their chief executive was charged with corruption. And according to Swiss rules, the way they portray it in the media is they name